The Article 50 Supreme Court case is one of the most controversial and important constitutional law cases in a long time. For the first time ever, all 11 justices are hearing the case, and in an unprecedented move, the entire saga was live streamed on social media. And for me, it exposed the fact that a lot of people neither have a good grasp of our constitutional law, nor understand how our judiciary functions. Well, I'm a law student at the University of Nottingham, and I'm going to do my best to break it all down for you. If you find this video useful, I'd appreciate it if you could share it, and if you have any questions, please feel free to leave them in the comment section below. This isn't going to be super quick because it's not easy to quickly explain a complicated case of constitutional law like this. For that reason, I'm going to briefly explain some of the fundamental principles of constitutional law in the United Kingdom, and also explain how those relate to the current case before the Supreme Court. Before I go into the details, it's best to make clear that this case is not about whether Brexit should happen or not. That's a political question, and the court isn't bothered about political questions. All it cares about is the law. This case is simply about which body of the state has the power to give notice under Article 50. Is it Parliament through the use of their legal sovereignty, or is it the government through the use of their prerogative powers? So let's firstly have a look at sovereignty. In the United Kingdom, there are two types. We have legal sovereignty, which is held by Parliament, and we have political sovereignty, which is held by the people, by you and I. If we quickly close in on legal sovereignty or parliamentary sovereignty, it's best to refer to the most widely accepted definition, which is the one given by the friend of every first-year law student, A.V. Dicey, otherwise known as one of the most authoritative scholars of our constitutional law. Firstly, he said that Parliament has the right to make or unmake any law whatever, which basically does what it says on the tin. If Parliament wants to make a law, it can make a law, and if it wants to get rid of one, then it can. It can basically do whatever it wants, legally speaking. But can it really do whatever it wants? Sir Leslie Stevens in 1882 stated that Parliament could legislate to have all blue-eyed babies put to death, and believe it or not, yes it could, but we can be reliably assured that will never happen. The people of this country would revolt, it would never get passed. So yes, Parliament can exercise its legal authority all it likes, but it can't avoid public opinion, it can't avoid political sovereignty, which is held by the people. And it's the people, I suppose, who are the ultimate check of power in our democracy. The second part of Dicey's definition is that no person or body is recognised by the law of England as having a right to override or set aside the legislation of Parliament. So what that means is only Parliament can repeal its own laws. The courts can't go against Parliament. They have to implement whatever Parliament decides to make into law. Likewise, the government cannot repeal an act of Parliament by itself. Only Parliament can do that. And I'll go further into that in a short while. And the third part of Dicey's definition is that Parliament can neither be bound by its predecessors nor its successors. I think that one's pretty self-explanatory. Just because Parliament decides to make a law one year doesn't mean that another Parliament has to abide by it the next year. New Parliaments are free to create new laws and repeal old ones. In other words, one Parliament can't make a law that lasts forever. So those are the basics of legal and political sovereignty, and I want to turn now to one of the fundamental debates in the Article 50 case, which is the scope of the prerogative powers, or the royal prerogative. If we go back centuries in our history, the monarch had absolute power. Then we had Magna Carta in 1215, which began putting limits on the monarch's powers, after which during the Middle Ages there was the gradual establishment of both houses of Parliament. And ever since, Parliament has received more and more power, especially after the Glorious Revolution in the 17th century, where King James II was overthrown. And in modern times, we see the monarch as simply having a ceremonial role. That's partly true, but because we never actually abolished our monarchy like many of our European neighbours, we never fully got rid of all of the Crown's powers. So whilst Parliament is sovereign, there's still a residue of discretionary powers that the Crown still has. Now, obviously the Queen herself doesn't exercise these prerogative powers. We say instead that Her Majesty's government exercises these powers on her behalf. In any case, prerogative powers that are exercised by the Prime Minister and other government ministers aren't really the subject of democratic scrutiny. It's an undemocratic exercise of power that was never taken away from the monarch and is now exercised by his or her government. The prerogative power that's in contention in the Article 50 case is the government's prerogative to make or unmake treaties on the international plane. Essentially, that allows the Prime Minister and other ministers to have some space when it comes to treaty making, without some of the arguably cumbersome democratic constraints that wouldn't be helpful in a climate of fast-paced international negotiations and decision-making. In recent times, with the Constitutional Reform and Governance Act 2010, or CRAG, there's a bit more democratic scrutiny over the making and unmaking of treaties, but the government still enjoys prerogative powers in this area. Why, you might ask? The simple answer is that no treaty the government signs on the international plane has any effect in the United Kingdom. We can say it has no domestic effect. A quick example is the European Convention on Human Rights. Our country helped write that treaty and we also signed it in the early 1950s. And that meant that we had to obey it in all other countries that are signed up to the convention. But that had no effect whatsoever in our country until the Human Rights Act of 1998 was passed. Now it's not just an international treaty anymore. It's part of our domestic law. So what the government does on the international plane is all fine and well, but that has no effect in UK law. It was perfectly fine for our Prime Minister at the time, Edward Heath, to finally reach an agreement with France so that we could join the European Communities, but Parliament had to give effect to it, and they did that through the European Communities Act 1972. According to the same principles, the government, by exercise of its prerogative powers, can't override legislation or laws enacted by Parliament. Now that creates a problem for the government because what's currently being argued in the Supreme Court is that giving notice under Article 50 will end up nullifying the European Communities Act. Before going any further, what is the European Communities Act? Basically, it was the act that made our country a member of the European Communities, which later became the European Union, and it's an act of huge constitutional significance. Because of that, the European Communities Act is unaffected by something called implied repeal. And the doctrine of implied repeal states that where two acts of Parliament conflict with each other, the one that has been enacted later will be taken to repeal the earlier one. Now, going back to what I said about Parliament being unable to bind its successors, implied repeal allows for new laws to be constantly made, and simply by enacting them, you've impliedly repealed the old law. But as I said, because the European Communities Act is a constitutional act, it's not enough to simply pass new laws that contradict it or get rid of it and then say, well, that's it, this new law we've passed gets rid of it, or it allows us to get rid of the European Communities Act. In order to do that, Parliament would have to expressly repeal it. It would have to say something like, this new act repeals the European Communities Act. It would take a clear and express statement to repeal it. Now let's turn directly to the Supreme Court case. The question before the court is basically, does the government have a prerogative power to give notice under Article 50? If it doesn't, then that means it's up to Parliament to decide. Now, you might think, well, the referendum result was to leave the European Union, that's very clear, so why can't the government just get on with it and give notice under Article 50? But there are two reasons why this is being debated as a point of law. The first reason is Article 50 itself. Article 50 of the Treaty on European Union doesn't actually say how an individual member state should give notice. It doesn't say whether it should be the government or whether it should be Parliament. It simply says under Section 1, any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. So, not particularly specific. The second reason is that in the European Union Referendum Act 2015, Parliament does not confer any authority on the government to give notice under Article 50. Parliament has never, in any act of Parliament, given the government the power to give notice under Article 50. If Parliament wanted to, it could have done, but it didn't. We can directly contrast that with another referendum where Parliament did give the government the power to directly follow through on the result, and that was clearly demonstrated in the United Kingdom Alternative Vote referendum in 2011, otherwise known as the AV referendum. So let's take a quick look at Section 8 of the Act, and what we see is a clear legal trigger that sets out the process through which Parliament would implement the decision, as in if the majority of people voted to accept the alternative vote system rather than first past the post, the legislation makes very clear how that would be legally implemented. It says, the Minister must make an order bringing into force Section 9, Schedule 10 and Part 1 of Schedule 12 if more votes are cast in the referendum in favour of the answer yes than in favour of the answer no. So the clear difference is that here Parliament has given the relevant minister the power to begin the legal procedure for implementing the outcome of the referendum, and in the EU Referendum Act 2015 that simply doesn't exist. The EU Referendum Act simply says that there should be a referendum, and it sets out the rules concerning the date and how it should be conducted. The EU Referendum Act could have said the Minister must give notice under Article 50 of the Treaty on European Union. If more votes are cast in the referendum in favour of the answer leave the European Union than in favour of the answer remain a member of the European Union. But it doesn't say what should happen if we vote to remain or leave. That's why we're having to debate it now. So moving on from that, let's look at what Article 50 actually does and what the consequences of triggering Article 50 are. And well, the first is that once a member state gives notice to withdraw, there's then a 2-year period in which to negotiate a withdrawal agreement. And it doesn't matter if no agreement is reached in that time. Once 2 years have gone by, the EU treaties will stop applying to the member state that's decided to withdraw unless the European Council unanimously agrees to extend the time. That's made even more serious by the fact that the notice can't be conditional, it's absolute. You can't trigger Article 50 and then say, oh, but our Parliament will have to approve any withdrawal agreement that we reach. It's very strict. It doesn't matter if there isn't any agreement. It doesn't matter if our Parliament doesn't approve of the agreement. After 2 years, you're out and tough luck. So the argument against the government is, yes, giving notice under Article 50 sets out the negotiation stage of the treaties, but it also means that in 2 years' time, we will cease to be a member of the European Union, and that will have huge consequences for our domestic law. And it's argued that the government simply cannot do that. The government can't make decisions using the prerogative that will affect our domestic laws and affect the rights of UK citizens. And going back to one of the elements of Dicey's definition of parliamentary sovereignty, that no person or body is recognised by the law of England as having a right to override or set aside the legislation of Parliament, it's clear that that would in fact be the case within 2 years if the government triggers Article 50, because not only are they beginning the negotiation period, they're also bringing the end of the European Communities Act 1972 and all other domestic law that is relevant. And let's not understate that, because the European Communities Act has had a colossal impact on the majority of the legislation that Parliament has passed in the last few decades. And at the end of the 2-year negotiation period, it's possible that hundreds of laws could be affected, all without the approval of Parliament. Before I go any further, a quick disclaimer. Judges often play devil's advocate. Their comments and questions do not necessarily represent their personal views. And with that, we can continue. Now, when Lord Panic QC made this submission in the Supreme Court, he and Lord Neuberger, the President of the Court, had quite an interesting exchange. They're talking about the Referendum Act 2015, and Lord Neuberger says, it could be said to be a bit surprising that in a flexible constitution, an act such as the Referendum Act and an event such as a referendum has no effect as a matter of law. This act may be enough for the government to say, Parliament has ceded the issue as far as Parliament is concerned to the people, we can now go ahead. Interesting. What Lord Neuberger argued is that perhaps Parliament gave away its sovereignty to the British people to make the decision whether or not to leave the EU, and depending on the outcome, the government can then go ahead and decide what they want to do. Now, Lord Wilson didn't seem to agree with that. He said to Lord Panic, isn't Parliament more likely to have said, having called for the referendum and when it has been done, we will assess the significance of it? So there's two competing arguments there. Personally, I don't agree with the argument that Parliament said the people can decide and then the government can act accordingly. It doesn't make sense to me that the government, on the basis of the referendum, has the authority to nullify the European Communities Act 1972. I agree with Lord Panic that for Parliament to allow the government to frustrate or nullify a constitutional act, Parliament would have had to have expressed that with the clearest of statements in the Referendum Act 2015. To me, that fits in with the idea of implied and express repeal. If Parliament was going to give the government the power to effectively repeal the European Communities Act, it would have had to have said that clearly. However, as I've already explained, Parliament said nothing in the Referendum Act 2015, and because Parliament did not say what should happen if there was a vote to leave, I find it more likely that Parliament intended that it should have a fundamental role in deciding what happens next. It's very hard to accept that Parliament impliedly cut itself off from the decision-making process, especially when the issue is of such huge constitutional significance. So there you have it. For me, and I would say the majority of the legal community, it seems pretty clear that the government does not have a prerogative power to give notice under Article 50. Obviously, you can never predict the outcome of a court case, but I'm confident that the majority of the justices will choose to dismiss the government's appeal. As I've said, this has nothing to do with whether or not Brexit will happen. That's not the issue for the court to decide. It'll be up to Parliament to make the decision whether or not they choose to vote to give notice under Article 50. If you voted to leave, though, you shouldn't really worry. Parliament already seems to have made it pretty clear that they will vote to trigger Article 50. On the 8th of December last year, 448 MPs voted in favour of a government motion saying that they support triggering Article 50 in March 2017, and only 75 voted against it. Now, that's obviously not legally binding, but as I said earlier, MPs can't escape public opinion. They have the legal sovereignty to overturn Brexit, but it looks pretty clear that they don't want to face a public revolt by doing so.